case briefs, and so much more. LS Data's got what you're looking for.
In 1988, the Vermont Supreme Court addressed a dispute between the Vermont Department of Public Service and the Massachusetts Municipal Wholesale Electric Company, MMWEC, in a case that focused on the legality of contracts between Vermont municipalities, electric cooperatives, and MMWEC. In 1979, 4 Vermont municipalities and 2 electric cooperatives agreed to share a 6.001% ownership interest in 2 nuclear power plants located in Seabrook, New Hampshire, as part of Project Number 6. However, in 1985, Vermont Department of Public Service filed a lawsuit against MMWEC and the Vermont utilities, alleging statutory and common law violations in the take-or-pay provisions of the contracts, transfer of decision-making authority, and non-compliance with voter approval and Public Service Board requirements. The Vermont Superior Court initially ruled in favor of the defendants and granted a summary judgment, but the plaintiffs appealed. The Vermont Supreme Court ultimately reversed the lower court's decision, ruling that the contracts were void ab initio, or unenforceable, due to the ultra vires nature of the agreements. The court determined that Vermont municipalities and electric cooperatives can only enter into contracts for the purchase of electric current for sale and distribution, and not for other financial obligations, such as project capability or the transfer of decision-making authority. The case was returned to the lower court to rule on the defendants' affirmative defenses, and the Vermont Supreme Court did not consider the consequences of voiding the contracts, as they determined it was the responsibility of the legislature to address policy considerations.
Case briefs, and so much more. LS Data's got what you're looking for. Visit lse.law, elevate your mind. Leave the stress of class.